Hello viewers, today we will discuss regulation of certifying authority. Information communication technologies have played a commendable role in our lives by producing, disseminating and receiving information and in the flow of ideas. A person can easily contact other person on the other end of the globe with just a few clicks. In this regard, UNESCO has played the leading role by ensuring that the masses benefit from these opportunities and also address legal and ethical issues relating to cyberspace. Furthermore, in 2006, the Global Alliance for ICTs and Development has been launched by the United Nations Secretary General to promote the integration of the ICTs in the development. For the integration of the ICTs in the development, transferring of e-record is an essential ingredient. However, while facilitating the transfer of digitally signed e-record, certain hurdles may preside. For instance, the e-record may be signed by someone who is not competent enough to do so. It has been rightly observed by the UN that from an international perspective, legal difficulties are more likely to arise in connection with the cross-border use of electronic signature and authentication methods that require the involvement of third parties in the signature or authentication process. Hence, the concept of regulatory authority and public key infrastructure, that is called PKI, was introduced. However, electronic signature and authentication methods supported by the certificates are issued by trusted third party certification service provider. In particular, digital signature under a public key infrastructure. Consequently, there is a need to pay special attention to international use of digital signature under a PKI. However, in this PKI, regulatory authorities are at the top and so its role is extremely essential. Indian law related to the information technology regulatory authorities and their working. In India, we have the Information Technology Act 2000 amended by Information Technology Amended Act 2008, which deals with cyberspace and the internet. Based on the model law on e-commerce, its main objective is to facilitate e-commerce under the IT Act 2000. There are two regulatory authorities. The one is the Controller of Certifying Authorities and the other one is Cyber Appellate Tribunal. The first we will discuss the Controller of Certifying Authority. The office of the Controller of Certifying Authority is a local point on which the Information Technology Act 2000 operates. It is statutory duty of the controller to identify, apply and draw awareness regarding application of specific form to technology. However, its main function is to issue license to certifying authorities who in turn generates and issues digital electronic signature certificates to the subscriber. Appointment of the controller and other officers, section 17 subclause 1 deal that the central government may by notification in the official gazette appoint a controller of certifying authorities for the purpose of this act and may also by the same or subsequent notification appoint such number of deputy controllers, assistant controllers and other officers and employees as it deems fit. Accordingly, the central government has appointed the Controller of Certifying Authorities on November 1st, 2000. However, the Controller of Certifying Authority has three main departments: technology, finance and legal, and investigation. In each department, there are deputy controllers, assistant controllers, and other officers and employees who work under the general superintendence and control of the CA. Then we will discuss the functions of the controller, section 18. The controller of CAs perform all or any of the following functions. The first one is supervises the activities of the certifying authorities. This function is further substantiated by the fact that the licensed certifying authority has to fulfill all the conditions stipulated by the controller. Further, under Rule 31 of the Information Technology Rules 2000, the certifying authority shall get its operation audited annually or half-yearly by an auditor and submit its report to the controller within 4 weeks of the completion of such audit. Therefore, the CCA shall supervise the CA through such audit reports. Certified public key of the certifying authority. For performing this function, the CCAs have established the Root Certifying Authority of India to certify public key of all CAs in India. However, the RCAI performs the following function. The first one is issue of license by means of X509 certificate, digital signing the public key of the licensed CA, generating the certification revocation list for the license issued, lays down the standard to be maintained by the certifying authorities. Regarding this, Rule 6 of the Information Technology Rules 2000 refers to the standard for different activities associated with CA's function. Specify the qualification and experience which employees of the certifying authority should possess. Specify the conditions subject to which the certifying authorities shall conduct their business. Specify the content of written, printed or visual material and advertisements that may be distributed or used by the CA in respect of an electronic signature certificate and the public key. Another one is specifies the form and content of electronic signature certificate and the key. Then specify the form and the manner in which account shall be maintained by the certifying authorities. Then specifies the terms and conditions subject to which the auditor may be appointed by the CAs and the remuneration to be paid to them. Then facilitates the establishment of any electronic system by certifying authority either solely or jointly with other certifying authorities and regulation of such system. Another one is specifies the manner in which the certifying authorities shall conduct their dealing with the subscribers. Resolves the conflict of interest between the certifying authorities and the subscriber. Then lay down the duties of the certifying authorities, maintain a database containing the disclosure record of every certifying authority containing such particulars as may be specified by the regulations, which shall be accessible to the public. Power of the controller of certifying authority. The CCAs have following powers. The very first one is power relating to license, which deals with section 21 to 26. Then power to delegate, section 27. Power to investigate contravention, section 28 deals with this. Power to assess computers and data, section 29. And power to give direction to the certifying authority, section 68 of the Act. Then power to make regulation, section 89. First, we will discuss power relating to the license. License to issue electronic signature, section 21. Subject to the provision of subsection 2, any person may make an application to the controller for a license to issue electronic signature certificates. No license shall be issued under subsection 1 unless the applicant fulfills such requirements with respect to the qualification, expertise, manpower, financial resources, and other infrastructure facilities which are necessary to issue electronic signature certificates as may be prescribed by the central government. A license granted under this section shall be valid for such period as may be prescribed by the central government, not be transferable or heritable, be subject to such terms and conditions as may be specified by the regulations. The aforesaid section underlines the facts that any person may approach the controller for a license to issue electronic signature certificate, including digital signature certificate. The said person is to submit an application under Rule 10 of the Information Technology Rules 2000. Furthermore, Regulation 3 of the Information Technology Regulation 2001 provides the terms and conditions of the license to issue electronic signature certificates, including digital signature certificate. Also, as per Rule 13 and Regulation 3 subclause 1A and BA, license is valid for a period of 5 years from the date of its issue, and the said license is not transferable and heritable. Then section 22 deals with application for license. Every application for issue of a license shall be in a such form as may be prescribed by the central government. Every application for the issue of license shall be accompanied by a certification practice statement, a statement including the procedure with respect to the identification of the applicant, payment of such fees not exceeding 25,000 rupees as may be prescribed by the central government. Such other documents as may be prescribed by the central government. Then we will discuss renewal of the license. Section 23 deals with this. An application for renewal of license shall be in such form accompanied by such fee not exceeding 5,000 rupees as may be prescribed by the central government and shall be made not less than 45 days before the date of the expiry of the period of validity of license. Then section 24 deals with the procedure for grant or rejection of license. The controller may, on receipt of an application under subsection 1 of section 21, after considering the documents accompanying the application and such other factors as deemed fit, grant the license or reject the application, provided that no application shall be rejected under this section unless the application has been given a reasonable opportunity of presenting his case. Then section 25 deals with the suspension of license. The controller may, if he is satisfied after making such inquiry as he may think fit, that is, certifying authority has made a statement in or in relation to the application for the issue of renewal of the license which is incorrect or false in the material particulars, failed to comply with the terms and conditions subject to which the license was granted, failed to maintain the procedure and standards specified in section 30, contravent any provision of this act, rule, regulation or order made thereunder, revoke the license, provided that no license shall be revoked unless the certifying authority has been given a reasonable opportunity of showing cause against the proposed revocation. The controller may, if he has reasonable cause to believe that there is any ground for revoking a license under subsection 1, by order suspend such license pending the completion of any inquiry order by him, provided that no license shall be suspended for a period exceeding 10 days unless the certifying authority has been given a reasonable opportunity of showing cause against the proposed suspension. No certifying authorities whose license has been suspended shall issue any certificate during such suspension. Notice of suspension or revocation of license deals with section 26. Where the license of the certifying authority is suspended or revoked, the controller shall publish notice of such suspension or revocation as the case may be in the database maintained. Where one or more repositories are specified, the controller shall publish notices of such suspension or revocation as the case may be in all such repositories, provided that the data containing the notice of such suspension or revocation as the case may be shall be made available through a website which shall be accessible round the clock. Provided further that the controller may, if he consider necessary, publicize the content of database in such electronic or other media as he may consider appropriate. Then power to delegate, section 27. The controller may in writing authorize the deputy controller, assistant controller or any officer to exercise any of the power of the controller. Then power to investigate and contravention, section 28. The controller or any officer authorized by him in this behalf shall take up for the investigation any contravention of the provision of this Act's rules and regulations made thereunder. Then we will discuss the role of certifying authority. Following are the very important roles of certifying authority. The first one is role regarding commencement of operation by licensed certifying authority, Rule 20. The licensed certifying authority shall commence its commercial operation of generation and issue of digital signature certificate only after it has confirmed to the controller the adoption of certification practice statement. It has generated its key pairs, there is private key and corresponding public key, and submitted the public key to the controller. Then installed facilities and infrastructure associated with all functions of generation, issue and management of digital signature certificates have been audited by the accredited auditor in accordance with the provision of Rule 31. And it has submitted the arrangement for cross certification with other licensed certifying authority within India to the controller. However, for receiving application from the subscriber, every CA appoints local registration authorities. Role to follow certain procedures. Section 30. Every certifying authority shall make sure of hardware, software and procedures that are secure from the intrusion and misuse, provide a reasonable level of reliability in its services which are reasonably suited to the performance of intended function. Then follow the security procedures to ensure the secrecy and privacy of electronic signature. Be the repository of all electronic signature certificates issued under this Act, public information regarding its practice, electronic signature certificate and current status of such certificates, and observe such other standard as may be specified by the regulations. Then role to ensure compliance of this Act, etc. Section 31. Every certifying authority must ensure that every person employed or otherwise engaged by it complies in the course of his employment or engagement with the provision of this Act, rule, regulation and order made thereunder. Role to display license. Section 32. Every certifying authority must display its license at the conspicuous place of the premises in which it carry on its business, so that public should know that he is the licensed CA. Then role regarding renewal of the license. Section 23. As license is valid for 5 years, therefore every CA must apply for renewal of license in case he wants to continue his business. However, an application of renewal of license shall be in such form as may be prescribed by the central government. There is the form mentioned in Schedule I, accompanied by such fee not exceeding 5,000 rupees, payable by the bank draft or a pay order drawn in the name of CCA's Rule 11, and made not less than 45 days before the date of the expiry of the period of validity of the license. Then role to surrender of license. Section 33 subclause 1 deals with Every certifying authorities whose license is suspended or revoked shall immediately after such suspension or revocation surrender the license to the controller. Then non-surrendering of license is an offence. Section 33 subclause 2 defines where any certifying authority fail to surrender his license, then he shall be guilty of an offence and shall be punished with an imprisonment which may extend up to 6 months or a fine which may extend to 10,000 rupees or with both. Then we will discuss rule regarding disclosure. Section 34 subclause 1 says every certifying authority shall disclose following in the manner specified by the regulation. The first one is its electronic signature. Then any certification practice statement relevant thereto, there is under section 2 subclause 1h. Certification practice statement means a statement issued by the certifying authority to specify the practices that certifying authority employs in issuing the electronic signature certificate. Then notice of the revocation or suspension of its certifying authority certificates. If any other fact that materially and adversely affect either the reliability of electronic signature certificate which that authority has issued or the authority's ability to perform its services, there is insolvency of the certifying authority. Then role of CA when any event has occurred or any situation has arisen which may materially and adversely affect the integrity of its computer system. Section 34 subclause 2 deals with where in the opinion of the certifying authority any event has occurred or any situation has arisen which may materially and adversely affect the integrity of its computer system or the conditions subject to which an electronic signature certificate was granted, then the certifying authority shall use reasonable effort to notify any person who is likely to be affected by that occurrence or act in accordance with the procedure specified in its certification practice statement to deal with such event or situation. For example, where virus has affected the electronic infrastructure of the certifying authority, immediately he must be a person who is likely to be affected by that occurrence. Or role regarding security guidelines. Rule 19, the certifying authority shall have the sole responsibility of integrity, confidentiality and protection of information and information assets employed in its operation, considering classification, declassification, labeling, storage, access and destruction of information assets according to their value, sensitivity and importance of operation. Further, information technology security guidelines and security guidelines for the certifying authorities aimed at protecting the integrity, confidentiality and availability of service of certifying authority are given in Schedule 2 and Schedule 3 respectively. Therefore, the certifying authority shall formulate its information technology and security policy for operation complying with these guidelines and submit to it to the controller before commencement of operation. However, any change made by the certifying authority in the information technology and security policy shall be submitted by it within 2 weeks of the controller. Then role to get its operation audited annually. Rule 31, the certifying authority must get its operation audited annual by an auditor and such audit shall include security policy and planning, physical security, technological evolution, certifying authorities service administration, relevant certification practice statement, compliance to relevant certification practice statement, contracts agreements, regulations prescribed by the controller, policy requirement of certifying authorities Rule 2000, half year or quarterly audit. Rule 31 subclause 2, the certifying authority must conduct half yearly audit of the security policy, physical security, and planning of its operation and repository. Submit copy of each audit report to the controller within 4 weeks. Rule 31, subclause 3. The certifying authority must submit copy of each audit report to the controller within 4 weeks of the completion of such audit. And where irregularities are found, the certifying authority shall take immediate and appropriate action to remove such irregularities. Auditor's relation with the certifying authority, Rule 32. The auditor must independent of certifying authorities whose job is to audit his operation annually and shall not be a software or hardware vendor which is or has been providing services or supplying equipment to the said certifying authority. Further, the auditor and the certifying authority shall not have any current or planned financial, legal or other relationships other than that of an auditor and the auditor party. Role before he ceased to act as a certifying authority. Rule 21. Before ceasing to act as a certifying authority must fulfill following conditions. The first is, he shall give a notice to the controller of its intention to cease acting as certifying authority. Further, the notice shall be made 90 days before ceasing to act as a certifying authority or 90 days before the date of expiry of the license. Advertise 60 days before the expiry of license or ceasing to act as a certifying authority, as the case may be, his intention in such daily newspaper and in such a manner as the controller may determine. Notifying its intention to cease acting as a certifying authority to the subscriber and cross-certifying authority of each unrevoked or unexpired digital certificate issued by it. However, the notice shall be given 60 days before ceasing to act as a certifying authority or 60 days before the date of expiry of unrevoked or unexpired digital signature certificate. As the case may be, such notice shall be sent to the controller, affected subscriber and cross-certifying authorities by digitally signed email and registered post. He shall revoke all the digital signature certificates that remained unrevoked or unexpired at the end of the 90 days notice period, whether or not the subscriber have requested revocation. He shall make a reasonable effort to ensure that discontinuing its certification services must cause minimal disruption to its subscriber and to the person duly needing to the verified digital signature by reference to the public key contained in outstanding digital signature certificate. Another one is, he shall make responsible arrangement for preserving the record for the period of 7 years. He shall pay reasonable compensation to the subscriber for revocation digital signature certificate before the date of the expiry. However, it must not exceed the cost involved in obtaining the new digital signature certificate. After the date of the expiry mentioned in the license, he shall destroy the certificate, signing private key and confirm the date and time of destruction of the private key to the controller so that he should not misuse his private key. So, these are certain points which are very important relating to the regulation of certifying authorities. Thank you viewers for watching this program.